Sorry.
Go right ahead.
Sorry, go ahead.
Hold on here. There we go. So the first thing is, this is provincial legislation. So this is the Ontario Not-for-Profit Corporations Act. So it applies only to provincial not-for-profit corporations, and you can be incorporated federally as a Canada under the Canada Not-for-Profit Corporations Act, or provincially. So there was the old Ontario Corporations Act, which is what they called at the time non-share corporations, which was not-for-profits and charitable organizations were under that act for up until October of 2021. So the first thing is to understand there are a lot of organizations out there that might be federal. And so you'll want to get a sense of whether your organization was federal or provincial, because if you're federal, now this doesn't apply at all. And it is possible that there could be some Rotary clubs out there that might have originally been incorporated federally. So that's the first thing to take a look at. As mentioned, the legislation, it was proclaimed October 19th, 2021. It was originally introduced in 2010, so it was a long road to get to proclamation, and with multiple government changes and such in between. But that's the official proclamation date, which matters because under the legislation, in theory, you have sort of 3 years to bring yourself into compliance with the legislation, and then it starts to automatically apply, which I'll get into a little later on. So the first step I was talking about was information gathering, and so this is just figuring out sort of where you're at right now, and so for each club, I think it's a good time with this legislation coming into force to just take a look at some of these things. The first is jurisdiction. I already touched on that. Are you Canadian, or are you a provincial not-for-profit organization? Is your club incorporated? If it is it by letters patent or articles of incorporation? So again, some clubs may not be incorporated. If you have a club constitution and you're just an informal association, you may not also be under this legislation. It's only if you are an incorporated entity and have either letters patent that were granted previously or what they now call articles of incorporation under the new act. So you'll want to take a look at those documents. You'll want to have your bylaws, and you might have a club constitution as well. So you'll want to take a look at those. Some clubs may have associated foundations that have charitable status. So a charitable organization is just sort of a special type of a not-for-profit. So again, it can impact the process when you're updating your documents. You'll want to look at your governance structure, number of directors you have. Do your articles or letters patent provide for a certain number of directors? Are you actually in compliance with what's in your articles currently? Do you have sort of board responsibilities set up? Do you have committees, standing committees, and so forth? And are those things actually set up in your governance documents? A lot of times we have organizations who might have well-standing, long-standing standing committees or other committees and things, and then they look at their governance documents and realize that none of that's actually in there, and it's all just been done by board resolution over years. So again, a good chance just to look at that and see. And then you're also going to want to understand the way your membership is currently set up, because some of those items are changing under the legislation. So, do you have different classes of membership? If so, in what document are those classes of membership set up? Are they in your bylaws? Are they in your letters patent? Is it just something that's been carried over and it's not actually documented anywhere in the governance documents? Do you have members who might be non-voting? Sometimes there's honorary members and things like that. There's some ways the new legislation impacts some of that. Sometimes you can have ex officio members, and also how are people becoming members of your club? Because the legislation does give some more power to members than in previous legislation that governed charitable and not-for-profit organizations. And so the way that people become members of your organization is important in the sense that you want to have an understanding of how new members might come to influence the organization and so forth. So that's the information gathering, things you're going to want to take a look at and have on hand. And then we've got our transition steps. So the idea essentially is that this new legislation came into force October 19th, 2021, and it applied to all corporations in Ontario that were not-for-profits or charitable organizations automatically upon proclamation. And then except that the legislation essentially said you've got 3 years from proclamation to amend your governing documents to conform with the Not-for-Profit Corporations Act. So in this intervening period, if your bylaws say something that is contrary to what's in the legislation, that still will be the case for this 3-year period. And then on October 19th, 2024, your bylaws, if they conflict with the legislation in some sense, will be deemed to have been amended to comply with the legislation. And so it means that you're not really offside. If you have bylaws that say something different, it's not as though they're going to dissolve your organization or really take any steps to deal with that. But it means that there could be confusion about what the rules really are. If you've got bylaws that say one thing, legislation that says something else, and you've got members and directors trying to make decisions for your organization, if you don't have both of these items in front of you, you might not know what the rules really are. And so really a lot of this is just to avoid confusion in governance moving forward once you pass that October 2024 date. There had been previous iterations of the legislation that had involved a transition where you actually had to continue your organization. You had to actually file documents or else they were going to dissolve your organization. And that was softened over the time period when the legislation was under consideration and before proclamation. So that's when people talk about being an optional transition steps, there are organizations out there that may do nothing, and they will continue to exist and there won't be any impact on their legal status. But again, some of these steps is just good to do at this stage because A, it's a good opportunity to update these things and take a look at it, and B, it'll avoid some confusion perhaps in the future in terms of how your governance applies. And so there's a few different things that organizations could choose to do that would be part of this transition process. And the first is adopting articles of amendment. So some organizations, you may look at your letters patent and realize a few different things. One is that it could be your letters patent set out objects or purposes for your organization, and you look at those and realize that what your organization or club is doing is no longer matching what is in those letters patent. A lot of times the clubs will have letters patent from the 50s or 60s, and they may say one thing, and if your letters patent say you're going to be a community organization for this particular region of Ontario, and in reality you're carrying out charitable activities in Africa, that's something you're going to address by amending your articles, because especially if you're doing charitable work, the CRA in particular and the Charities Directorate essentially want to know that every activity that your organization undertakes falls within or under a purpose or object that is set out in your letters patent or articles of incorporation. So you've got to be able to draw the line between what you have in your governing documents and what activities your organization is actually carrying out. So that's the one aspect of the articles amendment you may want to address. The other thing is there are certain items that need to be put in your articles as a result of the new legislation. One of those is different classes of membership. So it used to be some organizations would have classes of memberships spelled out in a constitution or in a resolution or even in bylaws. And the Not-for-Profit Corporations Act essentially says you've got to create those classes of membership in your articles. And so if your intention as a club is to carry on with multiple classes of membership, then you may want to consider amending your articles to bring those into the articles, or decide to take a different approach and no longer have different classes of membership so that you don't have to do the amendment process. So that's articles of amendment. And then there's adopting Onca compliant bylaws. That one is, again, just a matter of sort of updating things. In the Not-for-Profit Corporations Act, there are a number of different terms related to the governance organizations. Some are mandatory. So the Act basically says, this is going to be the case, and no matter what's in your bylaw, this is the rule. Other times it's permissive. So they might say in the Act that your organization could decide to permit something, or you could decide not to. And so in that respect, you just kind of have to think about what you want to have your bylaws say and whether you want to update that. So that's the bylaws. Both of these transition steps require you to do a special resolution of your members to approve it at a members meeting. That's all you need to do for your bylaws. So really for the bylaws, it's a fairly straightforward process. You create your new bylaws, you get them passed at a members meeting by special resolution, you have new bylaws. The articles of amendment are more complicated. You have to apply with the ministry and have them issued by the ministry. And if you're a charitable organization, there are more hoops to jump through because you need to ensure that the purposes and objects of your organization are fully charitable, and that is determined by the Canada Revenue Agency and their Charities Directorate. So you may want to have pre-approval of your intended articles of amendment. You file that with the CRA, you wait many months, and then you get something back from them indicating that they have approved it or with questions and comments about it. And then once you have their pre-approval, then you file your articles of amendment so that your organization has new articles in place. So that's the transition process. And then I wanted just to take you through some of the key elements of the new legislation and where it might intersect with your bylaws or articles. And so where you might want to consider whether updates or amendments are necessary. So for membership, this is where a lot of the changes come about in the legislation. The first is that your bylaws under the Act are required to set out the conditions for membership. So who can be a member of your organization and how they become a member. So you'll want to look and see if your bylaws currently provide for that. There is a default rule in place under legislation that there's one vote per member, unless it's otherwise specified in the articles. So this gets back a little bit to the different classes of members. For example, if you were going to have a class of non-voting members, that has to be in your articles or letters patent. If it isn't, you have to amend those articles or letters patent, or else everyone has to get a vote. And so that's the, you can certainly set out rules in your articles, and you can have different classes. Sometimes organizations might have, corporate members that don't have votes or honorary members who don't have votes, things like that. But if that's not in your articles or letters patent currently, you'll have to amend for that. And then there's members are given some additional rights under the new legislation as well. Some of these items are such as requisitioning meetings. So, 10% of members can get together and requisition a meeting. That's the highest percentage under the legislation is permissible. You can choose a lower percentage. So you could say, we're going to allow 5% of members to requisition a meeting, but you've got to have something in your bylaws, or you may want to have something in your bylaws about that in particular, or else the 10% applies. Members can also submit proposals to amend bylaws. They can nominate directors. They have access to corporate records. And they also have some remedy powers, which are things where members feel they're treated unfairly or the organization isn't doing what they're supposed to be doing. Then they have certain recourse through the courts that they maybe wouldn't have had before, that are more akin to what a business corporation would have. So that's sort of just things to consider. A lot of that, the members' rights, they have those rights under the Act, and there's nothing you can really put in your bylaws to change that, but it's more just being aware that that's out there for your board. There's also rules about members' meetings, which may come up in your bylaws. Sometimes bylaws will have in them specific provisions related to the notice before meetings. And the legislation says specifically in it, it has to be 10 to 50 days before the meeting. So if your bylaws say something different, you might want to amend your bylaws so that you're in line with the legislation. The legislation is also permissible with respect to proxy votes. So some organizations might have bylaws right now that say, you can't vote by proxy, or you can, and here's the rules. You have the right in your bylaws currently under the new legislation to decide, do you want to allow members to have proxy votes? Does the person exercising the proxy have to be a member themselves? What are the rules in terms of timing, and how's that process unfold? If your bylaws are silent on that now, you might want to consider adding some language to your bylaws to address that in particular. And then there's also rules related to the circulation of financials in advance of an annual general meeting. So again, some bylaws for organizations might say something different than what the legislation says. And so to make sure that you're compliant, this is going to be what the rule is, the 21 days before the AGM. Once that 3-year period is over, and if your bylaws say something different, you're going to want to make sure you've updated it so that your treasurer doesn't look at the bylaws and think the timeline's different, for example. And then there's some terms about directors. So the new legislation provides that members must elect directors by ordinary resolution. There's a maximum term of 4 years and no limit on re-election. So most bylaws don't provide for terms longer than 4 years, but it's possible. And so you'd want to make sure that you're on side with that. There's also provisions related to members removing a director. The Act says specifically that that can be done by majority vote. So again, some bylaws, if they're older bylaws, might say, that has to be done by special resolution or that can't be done at all. And so again, you would want to make sure that you've updated that so that it's in accordance with the legislation. And then the Act also provides that you can specify quorum for meetings of directors and meetings of members in your bylaws. So if your bylaws are currently silent to that, again, just so that everyone knows what the rules are governing your organization, you might want to decide to update that in your bylaws as well. And then we have committees as well. So there's, this is another one that's sort of permissive. The Act says that an organization can establish standing committees in its bylaws. So some bylaws will have those standing committees, but I know there are organizations out there where their bylaws say nothing about standing committees, and then they may have a club constitution, for example, that sets out their standing committees. So you might want to be importing some of that into your bylaws so that's in the right place. And with club constitutions, you may also want to be thinking about the interplay between those documents. There are, sometimes organizations might update their bylaws and then they will have a club constitution that now conflicts with what's in their bylaws. And that can create some confusion in terms of governance. So you might want to consider having, a provision in your bylaws that says, if there is a conflict, then the bylaws rule over the Constitution. Or you might want to amend your Constitution at the same time just to make sure that there isn't any conflict between those documents. And then the Act also allows you to delegate powers. So the board can delegate some of its powers, but only to a committee composed solely of directors. So, for example, if you're going to approve financial statements, that's got to be done by the board. They could delegate it to a finance committee made up of only directors, but they can't, if that finance committee has a non-director on it, then you can't delegate that process. Doesn't mean they can't still advise. You can have a finance committee that provides advice, but you're going to eventually need to have a motion passed at the board in order to ensure you're in compliance. So it's a good time to take a look at those committees, how they're set up in your bylaws, who the members of those committees are. Are you on board with this? And the Act does have some provisions that some things that you can't delegate. And so you'd want to just take a look at that. And you want to make sure that your board isn't delegating something that they don't have the ability to delegate to a committee. As long as your structure is set up in such a way that the committees are always funneling everything back up to the board, it shouldn't generally be a significant problem. If ultimately the activities of the committee are being approved by the board by resolution in some fashion, it's not necessarily an issue. But I know there have been organizations we have seen where they have things set up in such a way that they've really been delegating things to a committee that really need to be at the board level. That's my legalese legal warning. So that's really just a really quick kind of overview of, what information do you want to take a look at? The process for transition, which we can get into more details about, but that's sort of the very basic process. And then the last is the actual, kind of how the legislation interacts with your governing documents right now. And, it was, the legislation itself was more transformative in its earlier drafts, and then it was really kind of softened over the time period. So in the end, it's more an opportunity just to look at your documents to make sure that they're matching up with what your activities and your governance structure is right now. And then at the same time, taking a look at your bylaws and taking a look at your articles and just making sure that, there are those handful of things that the Act specifically provides need to be in the bylaws, need to be in the articles, making sure that you're on side with that. That would be sort of the ideal process for an organization. That's probably all that an organization really needs to do to be compliant. The more complex legal processes. If you're going to go through the process of amending your articles, for example, it's probably going to be driven more by, we have new activities going on and we need to make sure that our articles specifically provide for that work. If an organization is just looking at their bylaws and are looking at their articles and decides, we just want to do something to make sure we're in accordance with Onca, you really probably don't need to update or amend your articles just to be in compliance with Onca. There'd be something else driving that process probably. The bylaws, it's probably just a good time to look at your bylaws and make sure they're up to date, and that you're in accordance with the legislation. So that's the sort of short info session that I had here. I think I'm just open it up to any questions, comments, anything anyone's got. I'm happy to chat further about.
Dick Snyder, you have a question? Go ahead.
Yes, please. I think right off the bat, I'm wondering, we need to determine what we are. Are we a charitable foundation? Are we a club incorporated under the new legislation? Are we a public benefit corporation? What are we and why are we that?
Yeah, that really is step one. And there's and we can certainly, I can assist you with that. Like every charitable organization is registered, so I mean there's a database, so we can always look up and see, if an organization is charitable or not, if you have charitable status. And then it's really a matter of just looking at your letters patent, which will give you the jurisdiction and the act that you're under. It'll say either it's a Canadian or Ontario letters patent, and that sort of gives you the starting point. And then the public benefit piece is, I didn't get into that aspect of it, but there are categories under the legislation that can impact certain things, such as the way you're preparing financial statements, the rules that apply in certain cases, and it's based on the sources of income of the organization and the dollar amounts involved. So we've really got to look at that kind of with each organization to determine whether they count as a public benefit corporation, which puts some additional obligations on the organization.
Thank you. I have another question, but somebody else has a question. Go ahead.
Okay. We're going to go to Henry next. He had his hand up next, and then we can come back to you, Dick, after Aaron. How's that sound?
All right, thank you. I had a question in terms of incorporation status. I know our club is a charity. I know that we're provincially listed as a not-for-profit. What I don't know is if we are incorporated. Would we necessarily be incorporated if we are not-for-profit?
So if you're a charitable organization, generally you will be incorporated as part of that. But you'd want to see your organization's founding document. So if you have a letters patent or something like that, that means that you are an incorporated entity.
That was sort of my next question. In our searches through filing cabinets and such the like, so far I don't think we have actually come across anything that resembles letters patents or articles of incorporation. Mm-hmm. Some time ago I did write to CRA, and they sent us some documents pertaining to our original charitable status, but nothing, as I say, that would be headed as articles of incorporation. Mm-hmm. Where do we go next to try and find these source documents?
So the ministry and the provincial, it'd be the Ministry of Consumer Affairs. They keep changing the name of it. That would be the entity that would probably have those documents on file. So that would be, you'd want to reach out to them, and they would be able to assist in terms of at least providing those documents. That depends how old they are. I don't know. They might be able to confirm the status of the organization without being able to provide the document. I don't know how far back their records go, but that would be who I would probably be starting with.
And the okay, that was that. The legislation itself that you mentioned we should be referring to, is that also available on the provincial website?
It is. So there's, yeah, and I could send around a link to everyone too. I don't know if Catherine has, contact information and things. I can certainly forward that. But there, yeah, the full legislation itself is available on the Ontario legislation website.
Would we be able to understand it if we got it?
It's not overly dense. Like it's long, but it's not. If you're looking for something in particular in that legislation, what kind of resolution do you need to change your bylaws, for example? Like you'd be able to find it in that legislation. It's not that difficult. Yeah.
Okay. Thank you.
Okay, thanks, Henry. Erin, you were next.
Yeah, thanks. We have just recently redone our bylaws, and we adopted the Constitution and the suggested standard bylaws through Rotary International. I've gone through the Onca document all the way through, and there are lots of things that are not compliant that we're going to amend through our bylaws. I'm certain I'm not catching them all, but anyway, we're giving it a shot. But there are some things that seem to be contrary to what RI has recommended in the Constitution, and we just get rid of the things that Rotary International wants us to adhere to, or just how do you cope with some of those conflicting concepts?
Yeah, it's tricky that I know what some have done is they've adopted a constitution that is exactly what Rotary International provides. Then they've adopted bylaws that are in accordance with the legislation in Ontario. And then they have said in the bylaws, if there's a conflict between them, the bylaws overrule the constitution if it comes up. Which then means that in theory, you're on side with both in the sense that you can say you've adopted the constitution that Rotary International provides, and you can also say that you've got bylaws that are in accordance with what the province provides. The only problem is when you come to a decision on governance, you've got to then be looking at both to know. But I don't know that there's a good answer other than that. And Rotary International is not necessarily going to change anything to address one jurisdiction changing its rules. So you're you're a little bit stuck that way.
Okay. Any other follow-up questions, Erin? No. Okay. So we're going to go back to Dick because I think you had a second question, Dick.
Yeah, around the same subject. Basically, I always understood that the Constitution and a set of bylaws were two different things, two different documents, and that letters patent was a third document. It seems to me now that they want you to do away with your Constitution, make the items in the Constitution part of the letters patent, and then have bylaws in accordance with what they require. Is that generally correct or not?
Yeah, so I mean, I would say that the Constitution in some way, it probably is more akin to the bylaws for the organization. There certainly are elements of a standard bylaw that show up in what I would say is the standard Rotary International Constitution. And they can conflict in certain places. I would say the Constitution generally that I've seen goes further than the bylaws. It gets into things that the bylaws generally wouldn't get into. So they could certainly be standalone documents. It's more just a matter of addressing where they might conflict. The one caveat to that would be classes of membership. And that's the one thing where the new legislation says you've got to bring that into your letters patent or articles. And I know there are constitutions out there that create different classes of membership. And in that regard, you're right. That's something that the Constitution really can't cover and be in compliance with legislation. You've got to bring that into the articles if you want to have classes of membership. you know, yeah.
I'm just going to say, as far as membership is concerned, it seemed to me that the criteria for a member is that they have a vote, regardless of what you call them. If they have a vote, they're a member. So in our particular case, we have about 4 classes of membership, including those that have been referred to as associate members and honorary members. And in our case, our bylaws say that they get a vote. So they can be called members, I presume.
Mm-hmm. Yeah, so they would all be members. So the question in that sort of scenario is just whether you want to maintain the different classes. Essentially, if you're going to have the different classes, you need to determine, you know, in what respect are they going to be treated differently as members, and are those differences important enough that as an organization you decide we should take the steps to amend our articles to codify that properly, or are the differences between those members superficial enough that you decide, you know what, we're just going to call them all members and move forward in that direction.
Okay.
Thanks.
Some great questions here. We've got Rob from Southampton next, and then we're going to hear from Mike and Mark from St. Thomas. So go ahead, Rob.
Thanks very much, Matthew. Very interesting. Some of the question I had was related to Constitution and the bylaws, and I was just sort of interested in a general discussion of where the Constitution stands in the hierarchy of documents. You've kind of touched on it in the last couple of questions, but maybe you could just provide a sort of a general explanation of that.
Mm-hmm. Yeah, I would say that for an incorporated entity, your primary document is your letters patent. It's the document that establishes the organization's existence. And the most important items related to that, the organization's existence, are generally found in letters patent or articles. The bylaws support the articles or letters patent and set out the governance of the organization on a day-to-day basis. I would say that ordinarily the Constitution in that scenario, if you have both a letters patent and you have bylaws, the Constitution, I would say, is adjacent to the bylaws, but ultimately beneath the bylaws in terms if there's a conflict between those two items. The one caveat to that, I would say, if you were not an incorporated entity, you don't have letters patent because your organization is just an informal association. In that scenario, your club constitution really is the founding document of the organization. And in that scenario, I would say the Constitution probably is first, and the bylaws are supporting the Constitution in that scenario. But that's only for an organization that's not incorporated, and I think most probably are, but that would be the one difference there.
Okay. All right. Thanks, Rob and Matt. Mike Hurry, you have a question next? No. Oh, there he is.
Okay. I hit the wrong spot on the screen. So Matthew, I haven't paid a lot of attention to this because there were other people that were dealing with it. But so I was originally of the understanding that this only applied to foundations or organizations that had charitable status. But I think that was a misunderstanding. So this applies to both clubs and to organizations that have a foundation that have charitable status.
Yes. It applies to any incorporated organization. So any organization that is an Ontario organization that is either has articles of incorporation or letters patent, it would apply to them, charitable or not charitable.
So in our case, we have a club and a foundation, so we should be looking at the bylaws and constitution founding documents for both organizations and bringing them into compliance with this new legislation.
Yeah, I would do it with both organizations. That's it. Yeah.
All right, thank you.
And Mark from St. Thomas, I think you had the next question.
My question got answered.
Oh, okay, great. I don't see anybody else with questions at the moment. You're all muted. Oh, sorry, Dick's unmuted again. Go ahead, Dick.
On and on. Is a charitable trust a foundation?
So it would be, I would say a charitable trust would be different than a foundation. A foundation is a specific type of charitable organization, but it is an organization normally established by letters patent or articles of incorporation. A trust is a bit different. A charitable trust would be a trust that is, so it's established in a different way. You would have a deed of settlement or a trust deed to establish the organization. And then that trust could apply for charitable status with the Canada Revenue Agency. So they might do similar things, but they would be different legally in terms of the structure of the organization. And the Canada Revenue Agency, for charitable organizations, they have different rules for how a foundation manages its affairs versus how a trust or a charitable organization would operate.
Okay, thank you. One more thing. Somebody in maybe their great wisdom in the past incorporated our constitution and bylaws into one document. And so strewn throughout the document are items that would normally go in a constitution and items that normally go in bylaws. Would Onca accept a combination of things like that as long as they complied with their requirements as far as bylaws are concerned? Or is just submitting something that has both the names of bylaws and constitution in it, throw them off?
Yeah. So I guess a couple of things out of that. One would be that there isn't really an obligation for the bylaws to be submitted anywhere unless you're a charitable organization and the CRA requires you to submit it as part of a process you're engaging with the CRA. The Provincial Ministry of Consumer Affairs, they don't need to see your bylaws to begin with. Generally, they just trust that you have them, and it's more a matter of making sure that your organization knows how decisions are being made and governance is being carried out, and that it's in compliance with the Act. The second piece to that, I guess, would be you could combine those documents into one, and as long as there's nothing in your bylaws that is in conflict with the mandatory rules that are set out in the legislation, that would be perfectly fine. Your bylaws could go into other topics that are not addressed in the legislation as much as you want, essentially, without it creating any issue under this legislation. The biggest challenge with having too much information in your bylaws or having certain items in your bylaws is that you can only amend your bylaws by a special resolution at a annual general meeting or meeting of members and things like that. And so sometimes organizations, if you want your board to be able to make decisions with respect to certain items, if you codify something in your bylaws, you are in a certain extent restricting your board's discretion to pass resolutions because they can't pass a resolution that's going to be in conflict with their bylaws. So in amending those bylaws, you're just going to want to be cognizant of the fact that if you have various matters in those bylaws that the board, you might want to have the ability to get around at certain circumstances, you're going to make it more difficult for the board in that respect.
Thank you, Matthew.
Okay. Betty, you have a question?
Yes. Can you clarify the difference between a charitable organization that's a charity and a foundation?
So a foundation is, in some ways, is a type of charitable organization, but really the main difference is, you've got a charitable organization that is not a foundation is generally directly carrying out charitable activities. So its activities might say that they as an organization are directly providing the aqua boxes, or they are directly, engaging in, carrying out this particular festival, something like that. The charitable foundation, generally speaking, is an organization that is going to dispense funds to other organizations that carry out the activities. And so the foundation, the Canada Revenue Agency treats foundations differently. It allows them to accumulate assets for the purposes of supporting other organizations in carrying out charitable activities. Whereas a charitable organization that is carrying out the activities itself, the CRA has a problem if you start accumulating funds and not spending them on charitable activities. They're going to start saying, well, wait a minute, what's your club doing with all this money, and why aren't you, carrying out the charitable activities you said you were going to carry out? So that's sort of the difference between them, is really how they are carrying out their objectives is different.
Okay, so in our letters patent, the purpose of our organization, our charity, is for religious, charitable, or education. When we look at the registration under, I think, the CRA, it talks about the charity type being advancing education and supporting schools and education. It makes no reference to charitable activities or and basically our charitable foundation does a lot more than just this education aspect. So have we been registered too narrowly, and do we have to change our registration to something more general?
Mm-hmm. Well, it sounds like it could be a scenario where you might want to be amending your letters patent to match up with what the organization is carrying out now. You would have to think about what activities are there, I guess, and whether it's not so much broadening it as the CRA has very specific provisions of what they consider charitable or not, and so it's more a matter of incorporating other objects into your current objects. So in addition to advancing education, maybe your organization's also doing something related to poverty relief, and so now you really need to be including some objects in your articles that speak to that aspect of your organization's activities. And so you'd be kind of adding additional heads, of objects in your letters patent to make sure that every activity that your organization undertakes falls within that.
So I noticed under some of the purposes, it shows community charitable activities. To me, it sounds like our charitable is more in that category. Like we make donations to the hospital. We do have scholarships, but we do a lot of community improvements, which doesn't really fit under this education aspect if that's the only recognized purpose through the CRA.
Yeah, so that does sound like something where you might be looking at it, and it might make sense for the board to consider whether you should be amending the letters patent to bring them in line with what you're actually doing on the ground. And we'd have to take a look at the letters patent and see what you've actually got spelled out there, because sometimes the CRA might in their documents refer to you one way, but if you actually look at the letters patent, there's more there. So we'd have to take a look at it and see, but that might be a scenario where you've got to do that.
Okay, thanks, Betty. Colleen, you're up next, and then we're going to hear from David, Henry, Aurelio. We got a big list. Let's try and get through them. Go ahead, David.
Okay, some of us are from the same club. I'm the same club as Betty, but I'll ask a different question. So we have an incorporated club in Goderich, and as Betty was just talking about, we have a foundation, and we've been working on the bylaws first for the foundation, but I was wondering about the order that we should be proceeding in, which you talked a little bit about. So would it be fixing the bylaws for the foundation, getting those accepted, then looking at our letters patent, then moving to our incorporated club? Or should we be trying to throw all the balls in the air at the same time? How do we proceed?
That's a good question. I wouldn't say there's a right answer to it. In some ways, it might be good to start with the bylaws because it's an easy win, in the sense that you could update your bylaws without too much difficulty, bring it in line with what is going on and get your members to approve it. And at least then you've checked that off the list. The updating of articles is more complicated. You know, you're going to have to engage in probably back and forth process with the Canada Revenue Agency. It's probably going to take many months to really get headway on it, and then actually have it approved at a meeting and get it in force. So, you know, it might be good to start with the bylaws just because, you know, it would.
Foundation and the club.
It would, yeah, for both the foundation and the club, I would say. Doing them at the same time probably makes sense because oftentimes there's a lot of interplay between those organizations. You know, you want to make sure that you've got your standing committee set up in a way that, you know, one standing committee is reporting to the right organization, and, you know, you don't want a standing committee that's really governing the foundation reporting to the club and decisions made. Just how those bylaws work, how those committees are set up, it kind of all works together. So doing the bylaws together for those two, I think, makes sense. And then from there, I would say that, yeah, the letters patent is a more complicated thing. And so, you know, you could decide to do it all at once, but that also might just be a lot of workload for a volunteer run governance committee. So, you know, you gotta take your wins when you can get them and go from there.
Okay.
Thank you.
Thanks.
And if I could, I'd like to ask a question about virtue of their office that you mentioned in your notes there.
Mm-hmm.
So we're struggling with that virtue of their office. So the president of our club, by virtue of their office, becomes a director of our charity. Is that the right way to use that term, virtue of their office?
It
So
could be.
we have 6 directors right now of our foundation, and they are all past presidents of our club. That's the way we have it set up, and we like that. We want to continue it, and we're not sure exactly how to write that into our bylaws, or if we can, or that makes sense. What you were saying about virtue of their office, I'm not really sure how that works.
Yeah, usually the virtue of your office piece is referring to within the governance of a club itself, like one organization itself.
Oh.
So in other words, you've got a president. By virtue of being president, they are also the chair of the governance committee, or they may be, if they're the treasurer, they're also a director, and that just has to be the way it is. You know, if by virtue of being treasurer, you are a director, and the members can't say that you're no longer a director because you're a director because of your office as treasurer. It's different when it's between two different organizations, because I don't know that you could say in your bylaws, for example, that the members that a president of one club, by virtue of being president of that club, becomes a director of our club or our organization, which is in theory an entirely separate organization. I think you have to just do an election and just know as a matter of course that this is how you do it, and you could put that in policy. You know, that's the way it's operated. I mean, I suppose you could put it in the bylaws. There's nothing that would say that that's offside with the legislation necessarily. But it would handcuff you that that's always the way it has to be. And maybe you find some remarkable fundraiser who's not a past president who you really want to be part of the foundation, and now you can't do that. But that'd be my thought, I guess.
Okay, great. Thanks, Colleen. We're going to hear from David Daglish next, and then Aurelio.
Hey, thanks, Matt.
Just
when we're talking about the classes of membership, we have a corporate member, which can allow for up to 3 people, but there's not 3 votes. Is that sufficiently unique that we need to put it into our a higher level than the bylaws, or is that just a slight refinement on member?
Yeah, I mean, you could do it a couple different ways, because you could just decide, the corporate member is really not the member. The 3 members who are 3 individuals who become members who are part of that corporate member are the ones who are the members, and they are just regular members, and you just decide to admit them as members. And then if that corporation, decides to nominate someone else, then the one who was a member ceases to be a member and the new person becomes a member. and then you get around having to put it in your articles. If you were going to specifically say, you know, we have corporate members, the actual corporation is the member, and that is different than an individual being a member because they get 3 people to nominate, then I think that would have to go in articles of incorporation.
Yeah, I think the way it works is I think there's a corporate member, they can have 3 people showing up at meetings, but only one person can vote at the meeting.
Mm-hmm. Yeah.
And it's between them, they decide who votes, is
Yeah.
the way it was set up. So that sounds like a flag that we need to be concerned about.
Yeah, it'd be tricky to figure that one out. I mean, as long as, I mean, the corporation could just be deemed to be a member, but you'd have to specifically provide that corporations can be members. You know, the default usually is that members are individuals. And so you'd probably have to specify that in articles, I would think.
Okay, I think we need to go back to the membership committee and find out if what was their entire mode of thinking. What were they really trying to get through? Just say we have 3 members instead of just 1.
Yeah, because I mean, really, if it's just 1 vote, it really is just 1 member. Like you could have you could have someone become a member from that organization or corporation. They have 1 vote, and then you can permit other people to attend meetings who are not members. There's nothing wrong with that as long as the board is in agreement that they can be there. And then in terms of the voting, that person is voting. It's not inherent the corporation that's voting, it's that person who's been appointed member. They're not there, they can proxy vote to someone else who can vote on their behalf, and then you wouldn't have an issue. But that would be the only way to get around it, I would think.
Okay, thank you.
Work to do there. Aurelio, please, you could be next.
Yes. Can you hear me?
Yes, we can.
Okay, that's great. Okay, so my question is regarding the registration that Betty talked about. Just to clarify what Betty was trying to convey. So the little problem we have is that not that our bylaws are not kind of wide enough at this time, it could be made wider, is that the registration on the CRA only has one thing that you can put in there. At this time, the charity type says advancement of education, and then there's a category right below it that says support of schools and education. So this is the part that, you know, can these be changed? Because from last time that I looked, it appeared that you can, but there isn't anything really wide enough, unless I'm wrong. And Barry was saying that there was a category, meaning a little bit of a general category. And if that's the case, it would be a matter of changing our registration then of the category to be that more all-encompassing one. Matthew, do you know, top of your head, if there are categories there, or does Betty recall if there was a category in there that could be picked that would be more altogether, or does it really not matter as long as one of them that we pick is one of the ones that we do, then it would be all right.
So if I could just jump in there.
Yeah.
It appears that there's a category that says other purposes beneficial to the community.
Aha.
Yeah. It depends on, like, it could also be something related to your annual filing with the CRA. You know, if your letters patent set out a number of different objects, and then but the records that the CRA has just says this one only, it could be something to do with the annual filing, that it's just they're picking up on one particular object in your letters patent, and they don't have the rest listed maybe on the charities directorate page or something like that. But your charitable objects are whatever's in your letters patent. So if you've got multiple objects in your letters patent, that is what your charitable objects are, regardless of what the CRA's own records might show.
Okay, so that overrules then this, and this one is not then that important, whatever it says in there, provided that what we do is really in sync with what our letters patents say. Is that what you're saying, Matthew?
That's what I would say. Like if the CRA ever asked questions about it and said, oh, you're doing all these things, and we don't think these are part of what you're authorized to do. If you've got letters patent that spell out 4 or 5 different objects that include the items you're currently carrying out, and you can point to that and say, these are our letters patent, here it is, then you're going to be fine with them in that regard.
Okay, I think I'm okay with that. I understand what you're saying. Betty, is that okay?
Yeah.
All right. Okay. Sounds good. Now I have just one last question, very quick. A committee about the delegation to committees, and just to clarify, a committee that, for instance, deals with, say, the chili cook-off or something like that, that certainly can be delegated to to non-board members. Is this correct, Matthew?
That is correct. Yes.
Okay.
Certainly. Yeah. The things that can't be delegated are things like approving financial statements, electing new directors, sort of things that are very fundamental to the activities of the organization. But if it's something like a charitable activity that's going on, you can certainly delegate that.
Okay. To non-members of the board.
To a committee that has non-members on it. Yeah.
Okay. Thank you.
Bernard, did you have a question? I had you on my list. Where did Bernard go? There.
Well, it was just around the filing with the CRA, the annual filing. So could you just expand on that a little bit, Matthew? Like what constitutes what we have to do in that regard?
Yeah. So the annual filing. So and I'm just going to look up the name of the form because I never.
I think it's a T3010.
Yeah, that's the one. Yeah. So the idea basically is you're on an annual basis that's getting filed. And so it has some details in it about what your activities and financial affairs were in the last year. And they have this on the CR website, they have a directorate of all the charitable organizations. They sort of summarize on that what the activities of some of these organizations are. But sometimes they might be, if you're filing, references one of your particular activities or one of your objects and not the others, they might say, oh, this is what that organization is doing, and they'll put that on their website as the official organization's activity or objects, but it might not fully encompass what your letters patent say.
Okay.
Matt, do you have a hard stop here? Because I've got about 6 more people that have questions for
I don't
you.
have a hard stop. We can keep going a little bit. Yeah.
Okay, awesome. I'm trying to pick some people who haven't asked questions yet either. Charlene, did you have a question? And then we'll go to Aaron.
No, I have 2 comments to make.
Okay.
First of all, many of the clubs here tonight are located in either Perth or Huron counties. And just to make you aware that the United Way, Perth Huron, is doing a half-day Onca bylaws rewriting workshop on, I think it's May 18th. And I can send that email to Catherine if that's suitable, and you can circulate from there, Catherine.
That would be great.
That may be helpful to some of you. And the other thing, this is the first time I've sat in on the Onca, but Stratford's been doing this for a number of years, and David Daglish's committee has been responsible for that. We've gotten through a number of the questions concerning objects and eligible activities. Would it be fair to circulate some of our stuff as an example, say to Goddard or some of the other clubs, so they know how to tackle this picture that's broader than just education?
And I think we have shared that, but we could share that again, Charlene. That would be fine. I think that was shared at the end of the first meeting. But yes, if anyone wants to see those, happy to recirculate those. Thanks, Charlene. Aaron.
Yeah, I just had recalled that I went to one of our local lawyers who is a Rotarian and asked if they would help me just after we did the preliminary review. And they said no, that they wouldn't help. And the reason was because you need a specialized legal team or lawyer or office to help work through it. It's important to get it right the first time before you send it in. So this may be a conflict of interest question for Matthew, but do you highly recommend a set of experienced eyes before you actually submit something?
But I think it depends what you're looking at. If it's a matter of an organization updating its bylaws, that's something that the organization could do on their own. There's a lot of resources out there. I think what Charlene said there, the United Way, they've really been doing a bunch of things related to Onca and things to help organizations, a lot of small organizations, be able to bring their documents up to date. That's doable. And you're not submitting that document anywhere. Generally speaking, it's an organizational document that you're using to govern your own club or foundation. Where it gets more complicated is dealing with the Canada Revenue Agency on a charitable basis. If you're going to amend the articles of an organization that is a registered charity, that's where you'd need to have a lawyer assisting you with it, who's dealt with the CRA, because they are very beholden to precedent, and they have a lot of policies related to what is and is not charitable, and it's not user friendly to deal with them, and you end up with a lot of back and forth often. And so in that respect, it's I would say if you're amending articles of especially the foundation or a charitable organization, that's where you'd want to have some legal assistance.
Okay, thanks, Aaron. Mark, did you have another question? Where's Mark?
No, I must have pushed a button on mistake.
Okay. How about Henry? Do you have another question?
Yes, I do. So I'm not sure whether you call it on board with what we've been talking about or totally contrary, but a number of us, or some of us, participated in a webinar earlier this week were put on by Bloomberg out of Toronto, who I gather are an expert firm in this sort of field. One of the suggestions they've made, not real forcefully, was that you might be better off to forget about Onca and go straight to the Fed registration. What are your thoughts on that?
The trick there is, if your organization's currently incorporated in Ontario, it's a whole legal process to change jurisdictions. You have to continue your organization. First, you need to exit Ontario, then you need to continue in a new jurisdiction. It's very complicated to do. So it's not worth it, generally speaking. If it's an organization that's not incorporated and you are incorporating it, that's been my go-to for a while now, for really a decade, is to incorporate federally, not provincially, just because there's been all this upheaval in the provincial sphere. And the federal process, they amended that back in 2010 and it was done, and it's been enforced for more than a decade. And so for a new organization, there have been some appreciable benefits to incorporating federally rather than provincially. That's probably lessened a little bit now by the fact that Onca is in force and things are kind of moving along with it. But that might still be the recommendation, and I'm sure that's probably where that's coming from on their end.
Thank you.
All right, thanks, Henry. That was actually a question that Tony had sent to me to ask, Matt. Yeah. So thanks for asking that. Obviously, you're in the same club. Who else did I see who had their hand up that has it? Jim Felton. Jim, do you have a question? Where's Jim?
Yes, I do. Matthew, I'm with the Rotary Club of London, and thank you for all your support to date. Question on the letters patent. When I just went back and took a quick look at it, and there's no indication about membership in it at all. In our club, we have 3 ways of coming into the club. One is an individual member, another corporate member, and another family member. And when they come, that's really set up just to entice people to come, because the fees are different on the other 2. And it's the members that come in are the individuals. And as far as Rotary International is concerned, that's who we put down on the form. So if it were a corporation, the corporation pays the bills sometimes. But do we need to be putting that kind of thing in the letters patent?
Usually, if the membership groups or classes are otherwise treated the same, save and except to the fees that they pay, then what I would usually recommend in that scenario is that you would set up only one class member. They are the member. That can be put out in the bylaws. And then in your own policies, you can provide for what the fees are that are paid by members, and you can create discounts for certain individuals. If it's a family referral or it's, whatever the situation might be, you could create, if it's so a long-term member, they just don't pay a fee. You could do that, and that doesn't need to be spelled out in your bylaws. You can have your own separate policy on that item. And then you get out of the whole amending your letters patent piece just because of the membership classes. You have one class membership, but you just do some different things with the fees to avoid to reflect what you want to reflect, entice members to join.
Thank you.
Okay. So I'm not sure if the people who are left on the call that have unmuted themselves have questions, or you just forgot to mute yourselves again. So I've got Henry. No, I don't have Henry. Mark, do you have another question?
No, I don't. No.
Okay. Dick, do you have another question?
No, I don't. Thank you.
Okay. I'm weeding them out. Mark, no. Dick, no. Betty, have you another question?
Yes, I do have a question.
Okay.
So Matthew, if would we contact your office directly to set up a meeting that we could work with you on our charity?
Yes, yeah, for sure. I'm happy to help with anything. Yeah. So yeah, my contact information's there, and I can circulate it by email afterwards too, and I'm happy to assist.
Okay.
And so we can either find a way to I can accumulate all of the lists of people that would like to reach out to Matt, and we can, because I think there's some help that district can help, some ways that district can help here in terms of expenses. We haven't really determined what that amount is going to be yet, but for sure I can facilitate meetings between Matt and some of these other clubs if that's how we think we would like to proceed going on from here. Does that sound reasonable, Matt?
Yep, sounds great to me.
If anybody has any comments they want to make about that, you can just reach out to me maybe, and we'll go from there. How does that sound? Okay. So I don't show anybody else with a question. Last opportunity, if you have one, to speak up. So I've recorded this. And so if you want to tell other members in your clubs that it's available for them to review as well, that would be great. I'll send out some notes. Charlene has sent me a link, and we'll send contact info about how we can get a hold of Matt going forward. Thanks so much, Matt, for being here and answering all these questions for us. I think a lot of people have gleaned some new information about going through this complicated process. So thanks again for being here. And yeah, stay tuned for an update, everybody. Okay. Oh, Kelly, did you have a question? Oh, you're just waving.
Well, thank you very much.
Thank you.
Thanks for the opportunity. It was nice to see you around.
Thank you. Bye-bye. Thank you.